despite the facts of legal drinks yesterday night. I'm hoping you have recovered since last night of the morning sessions, and now you're looking forward to this very popular panel on subsoil use. My name is Viktor Nesterenko. I was asked to moderate this panel together with Evgeny Mazkov. Evgeny has long been involved in issues of subsoil use. He used to teach. He's also a lawyer and a doctor of law. He's now working at Rosneft on issues of subsoil. Evgeny, you have the floor. Good afternoon, dear colleagues. On behalf of Rosneft, it's my pleasure to welcome and greet you to this traditional roundtable on relevant issues of subsoil. It is a nice day indeed because our agenda today has been expanding. New challenges and issues emerge, but over the 20 years of the application of the existing laws and licensing regulations have had nice fruits, and quite a few issues have been addressed over the years, particularly in licensing of subsoil use and administrative barriers. A lot of work has been done by the Ministry of Natural Resources, and we have all been witnesses to very good results in that area. So I would like to give the floor to First Deputy Minister of the Natural Resources and Environment, Mr. Denis Khramov. Thank you very much. Thank you very much for the introduction. And I would like to welcome the people who have given the privilege of listening to us, despite all the drinks we had yesterday. And of course, Evgeny has already mentioned that life has been suggesting always some new ideas and challenges. We see some obvious challenges, some serious problems that have been our key obstacles, that is the ways to stimulate survey and exploration. But we have heard all about the natural resources and the Committee on of State Reserves. The structure of exploration has been deteriorating. The smaller deposits, natural fields have been leaving the market. We need to resist to the monopolization of this sector, which of course have very serious disincentives, particularly in junior exploration, and companies have been under-investing in exploration, and although they have a significant amounts for their appropriate capitalization, and of course the most recent developments of the past year and a half have not helped with sanctions and oil prices. So our need is to sustain the existing level of exploration and sustain the investment attractiveness of the sector, so that the missing government expenditure could be compensated by the private investments. One of our missions, of course, is to improve the legislation legislation so that we could sustain the sector. We need to provide for the environment that would be conducive to the continued exploration of oil fields, of the existing oil fields. The other important mission is to extend survey and exploration where in the areas where none has been done, in new regions which may be promising. Economically, this may not be very profitable, so we need to ensure there's a proper incentive. And there is also so-called non-traditional mineral reserves and resources, some HTRs, and I would give you some briefing on the key economic results, and I'm sure it will be followed up going forwards. And I will also tell you about our current plan of action. So what did we do last year to sustain the ongoing exploration? We have removed some of the barriers. We have defined the so-called accompanying waters or technological waters. We amended some of the improved the licensing regime, and we introduced new regime for the exploration wells. You don't need to obtain any additional licenses anymore. We also have provided for the conditions to use the land around the developed oil fields. We provided some tax incentives, some holidays for the forest. We provided grace period for the ongoing payments, and there will be some accompanying legislative changes. A law was put into effect recently that opened up the ways for licensing in the Baltic Sea exploration, and this is part of the strategic investment plan. We, together with the Ministry of Energy, working on the tax on fuel tax. We need to continue working on the classification of the mineral reserves. We are working on a new classification for solid mineral reserves. The Duma, and we cross our fingers, is expected to approve a law on geological information. So a few nice new things. We also have been doing something on a number of other areas. We have been working on Regulation 429 about the borders of the licensed areas, and this is just some of the areas of work that would ensure that the level at which the exploration is proceeding today will be maintained. So what can we do to motivate new prospecting and exploration? I'm sure my colleagues will follow up on some new steps towards the exploration incentives to obtain exploration licensing. We have introduced approvals for the development of government-owned areas for the purposes of exploration. Much has been done to maintain new entrants, including RusEnergyLaw. Very high-level decisions were taken for RusEnergyLaw to become the missing link in the chain between the regional geological survey and exploration done by private business. We're working on improving services to the federally important fields. We are working hard with pressurizing Ministry of Finance on reviewing the mechanism for deducting seeing the expenditures. Ministry of Finance says 1.5. We're saying we need 2 or 2.5% discount depending on the region. And then you're probably aware about this issue whereby tenders have only one bidder. We need to find ways to motivate shelf exploration, and the process is ongoing. And then, of course, there is yet another important area which we have already tapped, which is to introduce a special treatment vis-a-vis HTRs. We have introduced some of the parameters that would make operators eligible for preferences. We will be starting a pilot project to fine-tune this mechanism. And we are also working on the concepts for amending the current legislation to stimulate the so-called technological juniors, as we call them, that would allow them to apply non-traditional ways and technologies. We will license the area with a minimum package of permissions and licenses, and the only important term and condition for licensing will be to start exploration and development after 3 or 4 years of to start development after in production after 2, 3, 4 years of exploration. So if the pilot is successful, we will guarantee access to infrastructure. But then the other positive upside would be to get the necessary technologies. Otherwise, such fields as Bazhenova will never be developed. Well, I've given you a very broad spectrum of initiatives. I think I will put a full stop at the moment, and I'm sure we'll come back to many of these discussions later on. Thank you very much, Denise. As Evgeny has said and Denise has confirmed, there have been major amendments in the subsoil use legislation. To follow up on that topic, I would like to give the floor to Mr. Gudkov. Sergei Gudkov is the head of Rosgeol expertise. His presentation will be on some other changes in coming changes in the legislation. Could we get the presentation, please, on the screen? Dear colleagues, good afternoon. Thank you very much for this opportunity to talk to this distinguished panel. I would like to talk about the most important issues of managing of the allocated reserves. So it is exactly the allocation that we used to concentrate on and focus. We decided which agencies in Russia were to issue decisions to allocate reserves. And you know that in 2004 there have been some changes and the mechanism has been revisited many times, but what's due and dues to Ministry of Mineral Reserves, because they've changed their focus on the work that has to be done with the allocated balance, allocated fund of the reserves. The key governance instruments has to do with the expert appraisal and the approval of the project documentation, as well as as amendment of the existing licenses. In my presentation, I would try to describe the most one of the most important mechanism, which is amending the existing licensing, and we also touch upon the expert appraisal of the exploration project. But first, I need to introduce my institution so that you could get an understanding where we stand. We used to be called Center Rosneft. We were set up in 1998. Then we were moved to the Ministry of the Natural Resources. Now we are federal service, a federal institution. We are to do the expert appraisal of exploration projects, and we've been doing that since 2012. We also are to support the relevant federal service and do the litigation in courts. In October last year, we were also charged with ensuring organizational support to the work done on the reserves allocation by the government. These are the key missions that have to do with the licensing and the use of subsoil. Let me briefly touch upon the updating of license updating. It's one of the hottest topic in the area. In February this year, the president issued an instruction under which we were to make an inventory of the existing licenses. We had till 2016. We still have 18 months to do this necessary inventorying work. The instruction itself is very brief, but every word has a very important meaning, and it underpins all the work that we are doing in that area. So what should we do to do the inventory? We need to make a list of all the licenses, make them all look the same, follow the same format. We have already issued a number of documents, Order 56, which was issued at the beginning of the year, which describes the form of the licensing agreement. And another important regulation is to move the burden of exploration, is to improve the work done on the exploration project. The presidential instruction describes the terms and conditions under which this inventory is to be taken. This licensee updating has to do with solid and liquid reserves, but not anything else. And our preliminary assessment says we have to do about several dozens of licenses, several dozens of hundreds of licenses. We will have to deal with the exploration licenses, the technological licenses. We will draw the inventory of the current debts or any violations or ordinances issued by the Ministry of Natural Resources on environmental violations. The updating, of course, will only take place if the subsoil user has already remedied the outstanding environmental violations. So they got another 18 months to do that. So these are the key rules, and we are deliberating about two possible options. One would be at the initiative of the subsoil user or the initiative of the Ministry of Natural Resources territorial branch. So the documents will be drawn in accordance with Administrative Regulation 315. It is effective regulation of the Ministry of Natural Resources. We need to have a package of licensing documents. An application is lodged. We vet it, and the materials then go to the special board, and we issue the approval, the service of mineral resources service endorses that. We're talking here about several hundreds of licenses, from 300 to 400 at the headquarters, and about 200 in the regional at the regional level have already been vetted, have already been updated. We have also been working, preparing materials for the inventory at the initiative of the ministry, and it's all down to the Administrative Regulation 315, which allows to both sides to initiate this procedure, the subsoil user and the government. We have done a lot in that area. We have collected the necessary data. We have checked the compliance of the existing documents, and then our assessment suggests about 1,500 licenses which have no violations, and they could be subjected to this inventory. This is a voluntary process, and the essence of this procedure is that government will inform the subsoil user about the option. The list of the licenses is to be confirmed, is to be approved soon, and all of the documents under the current procedures are to be lodged with the territorial branches of the Ministry of Natural Resources. They will check and vet the package, and then will brief the headquarters of the ministry about the decision. So we will ensure uniformity and licensing and provide for better transparency of all decision making. Of course, it all depends whether the headquarters of the Ministry of the Natural Resources whether can stomach the total number of licenses. At the moment, a procedure stands for the headquarters to be involved in that, but probably this procedure will be revisited later on if the number of licenses is too high. I will very briefly tell you about this vetted license procedure. So the license after vetting will show all the necessary parameters complete with a statutory registration number. And the period of license will be subject to the project documentation. It will show the scope of exploration with a breakdown to years. And the level of production will depend only by the technological projects for the exploration of the field. So we allow for certain liberalization in terms of termination of the use. This termination at the moment is with the revocable with the presentation of the notification. Now this termination will only be subject to the violation of the financial conditions. In other cases, we'll just send notification and give certain period of time for the company to remedy the violations. The key documents to regulate the rights of the land use after the inventory will include this vetted license, the relevant projects, geological exploration and development, and they will basically be the same, or more or less the same, as the ones we have today. Let me very briefly talk about the expert evaluation, expert appraisal. We were instructed to do it 2.5 years ago. Quite a lot has been done over the period. In particular, I believe expert appraisal at the moment is one of the most neglected institutes in subsoil. Use very few regulations, only one article in the relevant law, Decree 202, and then in 2013 we approved the administrative regulation 303.9. We have studied the relevant expertise, and last autumn the ministry has introduced amendments, and they were put into effect in October last year. So the procedures have been streamlined. We eliminated some of the administrative barriers. We repealed the requirement to conduct the appraisal for the production and estimates of the project, the production requirement and estimate of the project. Companies that conduct exploration are only exposed to appraisal only in their technological expertise. So the only no changes have been done in contracts where government is a party to, but we're talking here about 10% to 90% of government versus private sector in exploration. We're talking here about 2,000 projects in the most common mineral resources. We have a unique status. We do expert appraisal for the locally important natural fields. We decreased the term for the expert appraisal.
Procedures for the appraisal of the geological nature of the subsoil, which is done in the same manner as other projects. Before we had the following procedure. You need to apply to the territorial bodies for the appraisal. They were assessed and then were sent back to the ministers. So now we changed the procedure. Documents are going or submitted directly to the ministers. We have 17 regional branches of our ministry, and we have formed them in accordance with the federal bodies. In Nizhny Novgorod, now we are going to set up in Kaluga, which will consider the project in the Central Federal region. So we practically cover all the territory of the Russian Federation, so by doing so optimizing our activities. We inherited quite a difficult or complicated system of the normative regulation dated back to 80s or early 90s. Many documents were adopted during the times of the Soviet Union. They deal with the project documentation. So now we face a very difficult challenge, which we try to solve. We have some progress in improving our normative legal framework to bring this into the compliance with the calls of time. Those dealing with the geological project are aware of how it is difficult to work on the basis of the documents of 90s, where the realities in terms of estimates of the projects have changed. This is the big task faced by us. Together with the Ministry of Natural Resources and other agencies, we will try in the near future to solve this problem so that to ensure the reliable conduct of the expert appraisal. So another important novelty, which turns out quite come in handy, so to say, when we amended the normative regulation last year, there was a requirement that geological study of subsoil should be accompanied by the schedule of this work. We are working in this direction, and we propose at the level of federal agency to establish the procedure for these regular schedules on solid fossil fuels and others, which allow us quite promptly reflect those tasks that are related to the expert appraisal of subsoil, because it requires a lot of time to work on and looking for specific schedules. Sometimes it's very difficult work. Now we are trying to establish a statistical basis starting from 2013 till 2011 to 2015. We set up this basis which reflects all projects of this kind and appraisals, and Rosneft will have a database which would reflect all changes related to the geological expert appraisal of subsoils. So they are now under consideration, but soon we will recommend them for approval. And just very quickly, somewhat on the introduction and amendments in licensing procedures and those recent changes which have been adopted recently. I would like to dwell on the Institute of Changes and Amendments, which is split in some cases prolongation of periods of amendments and justification for amendments, on substantial cases, on a volume of consumption of the products. I would like to dwell specifically on such forms as amendments in the licensing, as a change in the boundaries of the site, and a correction of the technical mistakes. These two forms, or two institutes, these two recent amendments were very hard to pass through in adoption process. These issues were quite pressing, especially in terms of changing of boundaries of the site, addition or annexes to the territories. Are they lawful or illegal? And there were some penalties, and decree of the government 425 introduced some justification of the change of boundaries of the site. This document is successfully implemented, and we at the same time face some problems. Life goes on, and therefore our agency, together with the Ministry of Natural Resources, have drafted the number of amendments which allow to solve successfully these changes, like the upper parts of the layer of the subsoils and change of boundaries in jurisdiction, which is quite important for Caspian region, where we have joint ventures with Kazakhstan in the water basin of Caspian Sea. Exclusion from the principle of establishment of joint sites or locations of subsoils where companies operate on the basis of the same project. Exclusion of other elements of the changes of boundaries in the hydrocarbons sites. As you know, in terms of changing to minimize the boundaries of a site, it's also possible with respect to the exploration, exploration and technical corrections. That was a very useful amendment adopted last year, just in the fading days of the last year. Government now has the possibility to rectify committed mistakes, technical mistakes. Now we have a special Article 7.1 on subsoil law on subsoil, which deals with the correction of the technical mistakes. It takes 60 days at the request of the user of subsoil, so it is established by the licensing body. In fact, we formed this institute. I wouldn't like to tell you about the typical forms of mistakes, and correction of technical mistakes is a very difficult process. Sometimes these mistakes date back to 90s, when there was a huge amount of licensing on use of subsoils. There was no common practice approaches. Many mistakes were made because of the human factors. There were different degrees, factors, and so on and so forth. And after instead of established figures, we received some strange configuration of the sites, and due to the activities of Rosneft and our agency, we managed to rectify the situation. And in my opinion, we need to start gradually developing this part of the management, start from the management of a division to the managing the divided assets. Thank you very much. Just a brief question, Evgeny. Specific question to Sergey. Or maybe after that. So our idea was, we're just now trying to identify all possible changes, we discuss them, and after that we will proceed with the environment. So Sergey touched upon many questions on the agenda today. Company assess this in a positive manner. We participate actively in all these processes, and in fact over the last 2-3 years of such an intensive activities by the government, we now feel some progress. Now we have a question where to go further in terms of improvement of the legislation. I would like to give the floor to Mr. Jabrailov. Can you briefly tell us what you are going to say? Yes. Good afternoon, ladies and gentlemen. Briefly, I'll try to be brief, since I'm a practitioner and I face these issues on a daily manner. I would prefer to go from induction to the more specific legislative things. Otherwise, I have to repeat those wonderful statements that we have already heard today. They are quite impressive. I witness what's going on in the market and in legislation. I've been witnessing for 20 years already, and I've never seen such huge changes and amendments in legislation. Some poor quality norms are replaced, but the correction of mistakes is also a very important thing. So, in the balance, we have a positive, gradual movement ahead. My points of intervention, actually, there are 2 points of intervention. Since this is a legal forum, and since this forum focuses on our specific roundtable, we are present now, focuses on promotion foreign investment in use of subsoil in the Russian Federation, I would like to identify 2 sets of issues. They are related to the most relevant things, which is quite a pressing thing, which we need to update up-to-date process. Yesterday my client called me with the same question. He has a licensed agreement which was signed back in 1995, and today's procedures do not provide for the availability of the license agreement. They provide for different things. I will come back to that at a later stage. The second element, so actualization, quite a mystic word. So this is euphemism, because someone are quite confused about what does it mean. Some think that this is the amnesty. Partially yes. As far as I understand, on the basis of my conversation, if a subsoil user approach or comes and asks for actualization, and he is in a default situation because he didn't manage to comply with the schedule and he hasn't started the implementation of operations that are scheduled for this time, like construction of mining factory, that would be a default. But if there are no further instructions of Rosneft or Rosneft, an instruction, then it can be excused. And like Sergei Viktorovich has said, that is another confirmation to that. But what is the actualization? How I see it? In 92, 94, many licenses have been issued. That would be license which confirm the rights of subsoil users. We had a perfect mining code in the Soviet Union, and the use of subsoil, and both licenses and mining permits existed in the same time. This is the inheritance of the Soviet Union. It's a normal and good thing. And in 92, 94, an unbelievable number of licenses were issued, and they were of bad quality. So just imagine a manufacturer is producing cars, and now we have rolling stock combining old cars and brand new cars. So now we need to streamline this somehow, to put it on a ground solid work, and this decrease 453 mentioned by Denis Ignatievich, it's in fact focusing on solution of those things that have never been tried to address or to deal with. We need to show the exact scheme of the site, previous or former users, brief reference information, background information. So it looks marvelous, quite civilized. But I have a question: why this order or governmental order or decree is intended for close use? Because it contradicts to the regulation 315 of the Civil Code. It's not registered with the Ministry of Justice, so it runs in contrast to law, to the provision of law on subsoil. Should it be studied carefully. From a practical point of view, indeed, probably, I would agree that, despite the law on subsoil states in Article 12 that during the period of validity of licenses and works, project activities, commissioning, they should be in the license or its annexes there too. But according to our order we have, they should be in the project documentation, but the project documentation is not the integral part of the license. Do we have here a contradiction? Yes, we do. No? Okay, let's discuss it. Going further, the agreement on the concerted use of subsoil. So let's put everything from the license and put it into this regulation. So changes of the license and technical or project documentation, these are two different things. That would be wonderful once it is amended in the law. Let's amend this first in the law, but not in the regulation, which is not approved or registered with the Ministry of Justice. So this is the problem. So the technique of the implementation, the notorious Order 65 adopted in 95, and Minister Loft urged all of us to implement this, but it contradicted to the federal law number 11, and after some years everything was moved to the law. So history is the mother of truth. So what are the lessons of? I worked in courts on this Order 65, trying to defend my clients. Why shouldn't we try to put this into the law? I understand that that would be a cumbersome process, but still, then the law provides for a possibility of signing a license agreement. Article 11 has never been repealed or revoked. According to the Order 65, we don't have such a possibility. You have what you have, or you have what you got, and you have license conditions without license agreement. Does it change anything? I don't know. I'm not sure I know the answer. I understand that courts can say this is a license agreement, but in fact this is administrative law which should apply here. This is 1% of the civil law and 99% of the administrative law.
From the practical point of view, what the change concerns, I don't know, but for foreign investors who effectively follow us, lawyers from international legal firms, they start prosecuting them. They start writing up letters, and then they would produce their qualifications. So they would say, okay, everything is fine, but going forward, this should have been done in this way, this should have been done in the other way, this decree has not been registered with the Ministry of Justice, so it may be null and void going forward. So what does that all mean? There may be no issue today, but it basically increases the cost of mobilizing foreign investments. Because these are all perceived country risks. And this reflects on the cost of their legal services, effectively. I can't conceal the facts when I talk to them. I have to be open with that. So I need to tell them that tomorrow this may come to court, and during the trial, the courts would refer to the law, because the court will not be interpreting ministerial regulations. They don't care if it had streamlined the procedure. The court would say that won't do, particularly after what happened with Rosneft. We know what could courts do in their judgments. I'm coming to the end of my presentation. We had this hope coming with the vetting of licenses that we've just discussed in 1992, 1994, and later many licenses were issued which could not be improved as they are. I came across many of such licenses where they were issued by the wrong agency. They could be bearing no seal or signature from the relevant service of the ministry. I don't think the vetting could resolve this debacle. So where's the limit to the vetting? So supposing I bring this license and I'm saying, this is a license that was issued, it's not my fault, we were not aware. You, the government, you've issued the license, you should vet it, you should update it, remove the wrong things, say this is a good sound license, and I go back home and continue exploring. I think this could be very easily resolved, and it's something for discussion, of course. If Article 198 of the administrative codes, we could say, amend it and say that for 10 years the licenses issued will be valid, and that would of course be of use for everyone. It will benefit everyone. We have these similar procedures in the civil code, but we don't have it in the administrative code, and it all has to do with the limitations period. This is an essential thing. We would be able to forget then about old cars running in our streets. No issue whatsoever. Well, that brings me to the end. Thank you very much. Thank you very much. And I would like to give the floor to Evgeny Tolubinsky from a Subsoil company, and he knows firsthand all those issues and amendments to the legislation. You have the floor. Good afternoon, ladies and gentlemen. Thank you very much for this invitation to sit on this panel. If we are to talk about legislation, I wanted to touch about the investment climate and some of the issues that we see in the sector. In the beginning, we have heard that the quality of mineral resources, fields and deposits have been consistently decreasing in quality and quantity. In terms of its mineral reserves and resources, Russia is no longer trailing the blaze in exploration and development. Survey and exploration, as well as production of mineral resources, is a highly competitive market, and this competition is global. My company and many other Russian players looking for reserves outside this country and prefer to compete for investment projects instead of developing projects here in Russia. Probably because we don't have anything of interest. We have a number of oil fields like Subsoil, which are still have not been allocated, but there are fewer and fewer of them, and companies tend to look in the West if they have the expertise. If they don't, they rely on the CIS opportunities in Kyrgyzstan and elsewhere. The competition is not only for the quality of fields, but also there is competition between legal systems. And we heard that during this forum. We have countries with world-class deposits like Mongolia or Guinea or many or others. They do not produce, they do not develop these deposits, and they are not too attractive for investors. There are countries with few deposits like Burkina Faso and Western Africa, but they found a way to attract and mobilize investment. They are now number 5 in Africa in terms of their GDP growth. If we move from the competition of legal systems to Russia at hand, we see that there are issues for the so-called junior companies or non-major companies markets. They don't come here. We have federally important deposits. We have been talking about them for ages. The Ministry of Natural Resources has been talking about them. But we want the regulators to set the tone. We won't see non-majors coming if we allow their fishing expeditions. If they get something large, it is up to the government to decide whether they could be allowed to develop it. If it's a small Australian or Canadian company, they may not get it. And of course, this is bad for our mineral resources. We have huge territories. This country is enormous, but we don't have the market of non-majors, so the juniors, if you want. And unless we have a competitive market, we will be losing. We will be going outside to Africa or elsewhere, but not in Russia. For majors, geological survey is not the key area. We need a market for the players who can do that. Of course, this mostly has to do with solid mineral deposits, and I urge you to study the law on subsoil use. Smaller deposits with less than 50 million tons may not be attractive. We need to make them attractive. We heard a lot about changes in licensing. We need to do more. We need to move to reserves P2 and P1. Dealing only with P3 is not enough, because we need to serve an impetus to exploration, the survey and exploration. As for mining and the new projects in the pipeline, I thought Russia could benefit if we improve, make the regulation more comprehensive. There have been a number of interesting projects with preferences in the forest, and we have been looking into those, but the government proved to be inconsistent. They introduced some limitations to the kind of players who could do. There are limitations to practical arrangements, and some of the companies were not allowed to combine licenses. There is high probability for the preferences in tax to be revoked if the license has been shown to be violated in exploration or in the development project. These preferences can be revoked. This is a major disincentive, and companies will hardly apply in their economic model these preferences. So these preferences do not serve as incentive anymore. In actually almost every region have added some additional qualifications to those tax preferences. Some of the models have been really unique. So we urge the government to be more comprehensive and consistent in regulation. And thirdly, I want to talk about tax disputes. If we are to discuss the issues that companies are facing, tax disputes, often because of their client-oriented of regulation by our regulator, the tax disputes now tend to be a more important issue than licensing. We had disputes on the subsoil use tax. The tax agency proved to be very creative. Some of the rates allowed to some companies cannot be applied by others. Some of the rates do not apply if we if the company has already completed the project, and some of the preferences are not allowed to it. So the sector could benefit to have the mineral extraction tax paid on revenues. The company wants to optimize its costs and cut losses, because with depth the quality of ore deteriorates, and then the tax authority demands more in terms of their taxes. It's absurd. Well, this is very briefly some of our concerns. What we want to see is a market of non-majors developing. We want to see more comprehensive approach to regulation in the sector and a better application of preferences in terms of tax. We want to see more consistent approach, particularly as far as the mineral extraction tax is concerned. Thank you very much, Evgeny. Dear colleagues, I think it's time for us to start discussing license, and John may make his contribution. I have one question to Denis or Sergei. You haven't commented on the recent amendments to Article 6 of paragraph 6 of the subsoil use law. whereby companies proceed from geological exploration to production. As a foreigner, I can't but see that you draw some distinction. It was a major issue, particularly where you have a pass-through license. It's true at the federally important deposit, you can't start production unless you finish the survey, and this could produce real production and financial pains. So the company, you improved on that, but you also made this qualification that if this deposit is controlled by a foreign company, it's up to the government. There is no automatic procedure. What was the cause for that? One would argue that probably you think that foreigners do not like to do survey and exploration. I'd say they probably like it even more than Russians, or at least as much as Russians. Could you comment on that? This must be the question to me. I failed to mention this initiative among many others. Those initiatives that have been already implemented. This issue of federally important deposits is not an easy thing. It's quite a complex thing. I'm relating here the position of the governments. It could be that when we take decisions, we actually have very heated discussions, and questions asked are quite strict, quite uneasy. We thought about allowing production before the geological exploration is over. And at this step of legislation development, the government prefers to introduce government control in the area of strategic deposits. This was a decision taken. This decision is not particularly unique to Russian laws. Almost all countries that develop their mineral resources have ways to impact transactions and mobilization of foreign capitals and exploration. And many countries fail to formulate the specific applicable criteria, which we did. Investors are there. The investors do their work, and those known majors who are in Africa or in Chile, if they want to come here, they do come. And as we know from experience, the government then takes decisions that stimulate investors to come. I could refer you to the most recent regulation issued by the government, whereby a very small non-major was allowed to use a deposit of nickel, and the company which is 100% controlled by Canada will be exploring mineral resources. So they worked with the government, and the procedure was completed. Yes, the government had to look and vet the project, but I think the government must have this right. It could not be refused this right. What we could do better, John, I think we could forget about this arrangement pertaining to the federally important deposits. We could forget about the subsoil use law, but then how could you work then? You keep issuing your very important, very good legal opinions to your clients, and whether we need to include in the license the paragraph paragraphs pertaining to the amount of investment. So probably that would lead to the increased cost of legal opinions. Yes, this may, but this is the way the cookie crumbles. And I also wanted to refer to this issue about licenses. It is up to lawyers to find drawbacks. They could comment on the Sermon on the Mount if they ask to. But the reference in the license to the technological project is exactly the reference to the allowed amount of production under the license.
As far as the complex approach is concerned, complex approach to the industry, I would say that we witnessed numerous attempts to rewrite the law. One draft law even was submitted to the parliament without first hearing. Why? Because the distinguished companies said that it would be easier for them to work on the basis of what they have. Okay, we start working on that. We develop a concept, and without any serious turmoils, we are moving gradually towards the implementation of this concept. So, as you said, we have now a positive balance. I would like to support what you have said. We believe that we need to go slowly towards this, down this way. We had a discussion in the State Duma on the civil codes amendments, and even there are some amendments to review the rights of the ownership of the subsoil users. So, in hypothetical use of civil transaction, we are talking about the improvements of the specialized legislation. That is why, in this sense, I would like to support you, Sergey. Your reaction? Microphone. On Article 6, each time I would like to think very much, but something prevents me to do so. So first, lawyers make money on legal opinion. The more issues they have, the bigger money he earns. But when there are too many questions, clients are no longer continuing deliberations, so lawyers are also not interested in having too many questions. So my personal interest is that it would be bad that we don't have any questions at all, because I will lose my job. But if we have too many questions, then it can scare off the clients. So if we had this legislation, then now we would have had a lot of investors which wouldn't like to leave the country because they invested a lot. And then the crisis came, and now it's more difficult to attract investments. This is why we are discussing this. An issue of legal technique. So far, I don't understand amendments to the Article 6. 7 years we have been discussing this article. This article doesn't create a balance of interest between state and investors. It's a lose-lose situation. It was bad for both investor and state. And the state should have invented something in order to take into account the investors' interests. With respect to the specific projects, and there was a need to do so. Today, Article 6, what it has now, so they just took away provisions regarding the obligation of the investor that they needed to complete the exploration circle, but at the same time they are not allowed to have geological exploration at the same time with the production. So why Article 6? Why do we have this provision? Because sometimes legislators forget about this. So now we have everything explored, and we know the volume of reserves of these subsoils. And it turns out that now we are or we are allowed not to conclude a geological study and start production. But once it's not completed, then at some point in time it should be continued. How it should be continued if we don't have a license? It says that the control on foreign companies cannot or is not allowed to conduct at the same time geological study, exploration and production. So we need to have more clarity on these issues for specific money. I'm not going to develop this discussion. We will have discussed this maybe individually. But I don't believe that you interpret correctly this. Let's continue our deliberations. We have a lot of adjacent studies, and we have a new version of a land code which attracted a lot of attention, and now we are looking how it will be implemented. We have serious reforms in the urban construction and environmental legislation. And in the framework of today's roundtable, we should discuss this issue. I will give the floor to Mr. Jarko, Alrut legal firm. Good afternoon. I would like to thank organizers and moderators for the possibility to speak at this session. The subsoil activities are related with the issues of the protection of environment, and it would be strange if regulator neglected or ignores this issue. The issue from the subsoil user perspective, from a practical point of view, is practically the same. What should I do in order to minimize the adverse impact on environment and to ensure the compliance with the regulation and to avoid huge costs for investing into new investors. Last year we made a lot of amendments into the environmental legislation, standards of consumption. So we have two blocks of legislative initiatives, one in June, the second in December. I try briefly to dwell on some issues of principles because we don't have enough time, and I would like to give other speakers to speak. Briefly, what can we say in terms of the law on the protection of environment, which suffered serious changes? In general, we are saying that these changes could be characterized as the course on large-scale changes of this legislation, and some of them are of declarative nature, and it is envisaged that it would be followed by a huge number of new bylaws, and we will witness how these changes would be implemented. In this sense, what I would like to say from the point of view of these changes, nature of these changes, we have a differentiation of the regulation of this law depending on the category of the facilities. There are 4 categories depending on their impact on environment. So slide, we have first level category with a maximum level. It is followed by moderate impact and minimum impact, and we have a differentiation of this with respect to the regulation applied to these categories. So far, in principle, subsoil users have enough time to get prepared to these changes which would come into effect on the BATs, which start entering into force from January 1st, 2019, and the procedures for environmental activities, projects related to this, which would be subject to approval from 2019, normatives for exhaustion or discharges, emissions, and limited period of these emissions which would be subject to some kind of payments for the impact. So much needs to be done by regulator and other initiatives, and I'm pretty much sure that the further implementation would depend on the social and economic and political situation in the country. When we don't have a big investment potential for the companies, it would be doubtful to put additional burden on the companies. That wouldn't be a sound decision, and law on emissions or wastes, it also is expected to be amended. Some provisions are expected to be softer. Here we talk about the law on waste, which was amended last December. Then, from the point of view of main things that have been done, these activities are subject to licenses in terms of processing, transportation and disposal of waste, and these requirements will enter into force from July 1st this year. First, these proposals were subject to disposal, and they end to cease to exist. And what would we do in this legal gap? Now we have initiative to postpone this period from 1st July to 1st October. This initiative is likely to be approved. Otherwise, some subsoil users will not be able to continue their operation because of expiry of their licenses and lack of prolongation of the licenses, as well as some regulations on the environmental protection program for environment have become tougher. So we need to find a sound balance in order to take into account the state, governmental interest and interest of the public, in order to mitigate the adverse impact on the environment and to ensure efficient work or operation of the subsoil users in this difficult context. I hope that we will have enough time, taking into account that many provisions will enter into force and will be adapted to the reality, and we will adjust our work accordingly. So I would stop here. I believe this question is quite difficult. We still need to think about details, so this is a red flag issue which should be taken into account by a subsoil user in its operation activities, and legal experts also should provide the legal opinion. We will see how the practice will be implemented. Thank you. Thank you very much, Andrei. Now we would like to give the floor to the representative of the Gazprom Neft, Mr. Vitko, who will tell about the increase in competitiveness of the Russian law on the example of the mining industry. I was listening with great interest the previous speakers, and I have a question to Gennady Viktorovich. May I start from asking this question? Does the ministry have the plan? We know the historically accumulated wastes, so let's say a refinery built in 1937, it is equipped with the purification system which is full of wastes. They should be removed. First, state imposed penalties, then regulates. So, do you have any desire to declare an amnesty so everyone will disclose their information about the history of the waste, so we calculated everything, give us 5 to 10 years and without any fines to dispose of this waste. The problem of waste is a comprehensive matter. We have a lot of locations with accumulated waste, and they are not the legal ground for some kind of prosecution for the owners of waste ranges. Sometimes it is the state which is paying for disposal together with the owner of these wastes. Range Black Hole and White Sea, where the state pays for removal of the toxic materials or wastes. We have the agreement with Sibur company and the region itself, saying that region pays partially for that, and partially it is paid from the federal budget. This problem is somehow addressed, maybe not such a manner as we would like to see. We developed a target federal program for accumulated toxic waste, but it requires a lot of funds or financing. We pay for this out of the budget. Maybe not much, but for this year this funding is limited. Now we have a moratorium for the introduction and adoption of new documents which require additional budget financing, but we continue to finance some constructions. We have a special governmental decree which identifies a number of objects which are supposed to be funded from the budget. They were categorized in terms of hazardous situation there, so the problem indeed exists, but we try to solve it. The colleagues try to be brief, and Irina represents the company which helped us to develop this project. She will continue. I don't know to what kind of a topic could it belong? Subsoil use or environment protection? I hope it's working.
I don't want to talk about the role of the mineral resources companies in the economy of this country. We have this sector provided the lion's share of the budget and made other important contributions, so mineral exploration is particularly applicable, particularly relevant. Probably I need to point out some of the specific fixtures, which is the high risk exploration project in oil sector has the success rate of 5 to 10. So you need to invest a lot. to do exploration, and Rosneft here would confirm in the Arctic, for example, the survey project. That is the phase which precedes industrial production from the deposits. Will require about $2 billion, and exploration would require up to 35 billion. It's a huge amount that you need to invest. It's expensive, the risks are high, liabilities are significant. You would remember what happened with the Smakonda platform. BP was very close to the brink. So it all suggests that the risks should be distributed, should be allocated. There's no one single company that could sustain all of these risks. So what sort of an environment we have in place in other sectors as well as in here? Traditional provinces has been depleting. We're moving to non-traditional areas into the shelf and the Arctic Sea, and as a result the costs mounts, and you only have about 2 to 3 months window for exploration in the Arctic Sea. For example, it's much more difficult to mobilize capital because of the sanctions. Markets are closed for us, as for many of our colleagues here. Expenditures and expenses are growing. We need new technologies to explore these deposits and many other things. There is competition. The Russian lacks in terms of its attractiveness for investment. There are other competing jurisdictions like Brazil or other oil-rich countries where investors choose to go. They have an option, they have a choice, and Russia is not their first choice. Hence, this investment attractiveness is key, and its components include fiscal attractiveness, financial attractiveness, so on and so forth. In Russia, there's very little, there are very few options for M&A. There's almost nothing left on the market. And the key issue that we see is that it is very difficult to mobilize investors, and it's all because the legislation doesn't offer modern remedies that would allow to allocate risks, if you have two plots, for example, from one and the same deposits, you can't work on them jointly. Or you take, for example, a field with some oil in it, you can't divide them into different projects. You can't share risks with your partners. In foreign law, there is this notion of finance carry, which is applicable to high-risk projects. What do you do for such projects? You find a partner who is prepared in exchange for getting access to take some risks. So the phase of exploration, if exploration is successful, partner continues with you to produce. If nothing comes out of the survey exploration, they part. The subsoil user gets its license, and the partner leaves with the loss of $2 billion. So what did we do in the past, and why I want to remind you about that? Why didn't we see the same problem? Actually, the problem was there all the time, but it is this legal tradition. We would rely on the English law, would set up a joint venture offshore with a partner, and the English law would be regulating this joint venture. I don't want to talk about the reasons for the choice of English law. It may be the traditional choice, it may be otherwise, but it just happens on the market. Now it has all changed, at least since last year. You can't apply English law for the shelf because the shelf is directly subject to sanctions. Consultants cannot work with you. So this is a deadlock that we're facing now. So sanctions could be broadened at any time. There's this uncertainty. There's risk of setting up joint ventures in offshore jurisdictions. You know about UCAS, and they really have very little chance of getting anything from the government through courts offshore. So this is not a way out. It's not the way to follow, it appears. I don't think we need to rediscover America. We have been working in other jurisdictions and in Iraq, in Iran, and other countries. These things happen. We have this high-risk operator agreement. This is the contract that allows you to redistribute some of the risks onto the operator. And worldwide, operators tend to risk to take just a little bit of risk, and the 5% is quite normal. So you have the pool investors, and of course, it is usually called a consortium, and you would have some kind of an agreement similar to a partnership agreement. It's usually called the joint production agreement in the sector. So basically, that is all that is used currently in foreign jurisdictions. I have provided some very brief description of these two instruments in the slides. So you redistribute risks and financial parameters, and under the joint production agreement, partners at the side of the operator will have to allocate risks, so to distribute risks. Why is it not possible to use the effective legal instruments in Russia? If you look at the operator's agreement as an agreement of contract, you can't allocate your commercial risks on the operator. Under our law of contract, you need to compensate the operators for their expenses, whether they find oil or not. These are principal importance for oil companies. If the contract does not deal the risk, you cannot operate. So oil companies are not drilling operators. They want to get their share of reserves, so share of production. So if you talk about your simple partnership, we have other issues. It is non-transparent from the point of view of tax. You can't assume or relocate losses. Your partners could leave the partnership quite easily. Now, if we talk about corporate legal instruments like setting up joint ventures, this is a possibility, but there will be a different taxation regime. Minorities will get certain rights to profits. This is quite an expensive arrangement because you'll have to have some management structures in place. You have to transfer licenses. You have to bear additional expenses. There'll be additional risks to license transfers. There are certain restrictions that apply to foreigners, particularly if we're talking about the shelf exploration. So what we propose is to introduce a Russian law with a separate law to add to the existing that would detail these two additional instruments, and they would help revive and stimulate survey and explorations on the shelf in eastern Siberia and others, where investors may not want to go, but they may want to go, but given the current environment, they don't do that. Thank you very much. Now, who would want to take the floor next? Probably Irina. Thank you. Thank you, Roman, for your interesting presentation. Irina Narshova will be to speak next. She's coming from the legal KPMG Russia, and she has something to say. Thank you, Evgeny Narshova. I'm the head of the legal practice, the KPMG in Russia and CIS. We're very grateful to the organizers for this invitation, to you, Evgeny, in particular, for this opportunity to contribute to this interesting debates. I thought of talking briefly about the work we've done with Gazprom Neft. We conducted analysis of possible amendments in the civil law legislation to introduce some arrangements that would improve the investment attraction of mineral reserves of foreign investors, and also address some of the issues that have to do with the development of such deposits that were described by Raman. When you have oil coming together with gas fields, and the license to oil exploration cannot be given to another company. I just want to remind you that several years ago, when there was much interest in Stockman, I talked to some Norwegian companies. We were discussing their potential investments in the oil and gas sector in Russia. We briefed them about the regulatory framework in Russia, and the question was, they asked the question, how possibly could you execute their investment? So our response was that there are very few products that could help in such a situation. The current energy strategy of the Russian Federation seems to be quite ambitious in terms of the development of the exploration and mineral reserves based on innovations. It's no secret that technologies available to Russia have been lagging behind the global technologies. Foreign investors will bring not just cash but technologies, and Norway is one of the leaders in that respect. And in that connection, it seems to be appropriate to offer something to our investors in terms of remedies or legal products that would safeguard their interests, not just their interests, but also interests of the Russian domestic subsoil users. As Roman told you, the very first reaction when you talk to laws about those high-risk operator agreement and consortium agreements, they would tell you you've got the law of contract and you've got the partnerships. But the fact is, we do not use the concept of risk reallocation. There are other major drawbacks in the simple partnership. We consider the position of the relevant partners. But if you don't want to go into much detail pertaining to civil law, I think there's another issue which has to do with the exercise of the freedom of contract. You may not agree with me, but in fact, the resolution 54 of the Supreme Court on construction was very illustrative. They said that investment projects should be interpreted only as a contract or as a sale agreement, and they closed down one of the venues that could have been used in construction. The purpose of that is not clear, but it was very illustrative because the freedom of contract is not easy to exercise here. And this may be key in our thinking if you want to entertain this idea of introducing high-risk operator agreement or consortium agreements. If we want to see them taking roots here, it would be imperative to allow partners the maximum freedom of modeling their relationship to the extent to which it doesn't touch on the public sphere and the public interest sphere. We don't want to see too much of the regulation whereby the government would prescribe the exact way the risk should be relocated. Let the partners, let the parties decide how much appetite, risk appetite they want to have. They should not be obliged to negotiate only along certain routes, unless, of course, it touches on the public domain, public interest domain. This is very important to take into account in legislative drafting. It is particularly relevant to the sector in question. It is not an abstract issue. This sector is one of the pillars of the Russian economy, so we're hopeful this idea may help. Thank you very much, Irina. While we have been working on our panel, we try to get the broadest possible range. We had government, we had consultants, we had Subsoil users, and we want to also ask John Heinz from Morgan Lewis. He will be talking from the perspective of a foreigner, and this is the eternal issue: what is to be done? Thank you, Evgeny. It's very good that I was given the floor at the end of the discussion because I may be touching again on some of the issues already addressed to sum them up. I'm particularly gratified to be here in St. Petersburg. 40 years ago, I came to the Soviet Union for the first time. I spent summer then in St. Petersburg learning Russian. Since then, my life has been essentially Russian, professionally and personal. So it is my pleasure to be here again. I want to comment. And I know that's probably you may not see I couldn't possibly see that, but it doesn't matter. I don't have too many words on my slides. I've got some pictures and charts showing trends, upwards or downward trends, and some figures that you can see. I may be provocative in a way, but this is the role foreigners tend to play. But from what I've just heard, I may be more pro-Russian than some of the previous speakers.
So we'll see. That would be the mixture of плохого, хорошего. So this brief introduction to the slides, which I will demonstrate. And on the first slide, I say that picture worth 1000 words, and these figures are dedicated, or they show situation in Russia, current situation in Russia, from maybe not legal point of view, maybe a shift to the economics. It does matter for the development of the sector of oil and gas. So the statistics and trends on GDP growth in Russia and FDI. What is interesting, where Russia now stands, I wouldn't like to repeat the figures for other countries. Everything is quite relative, and Russia sometimes can hardly be compared with other developing countries like BRICS countries. But on the other hand, you should always remember, when everyone complains that we don't have much FDI and that leading economies, Western economies, their level of FDI vary quite significantly. Sometimes it is in red, in negative, plus or minus, so it varies quite significantly due to many factors. And in the end, I'm saying that, so just to sum up this slide, those countries which has not much of influx of FDI, it could compensate using domestic investment, and unfortunately Russia doesn't have such a possibility as we would like, and therefore those countries which have negative influx of FDI, it means that these countries invest in a lot abroad, and they receive a lot as they invest. In Russia we don't have much we don't have much Russian investment abroad in other countries. This line in red shows the trend of growth in emerging markets. I mean the GDP growth starting from 2008 till 2013, and this boxes in blue show the trend in Russia. So initially we had the growth, then it was going down practically up to zero, and this year it would be in negative figures. And here we try to use a different pattern to show the fluctuations, the surges FDI. This surge, upward surge, this due to the purchases of the subsidiaries of Rosneft by BP, and now we see the downfall. And on the right hand of the slide, we see the net capital flows in Russia over these years, starting from 2008 and until now. So there is everything is in minus, and we know that there is a huge capital flight of the Russian capital abroad. And here a quarterly depiction of the foreign direct investment into Russia. You see the surge in the 2013, upward surge in 2013, and this year is expected to be quite low. This slide shows the overall volume of FDI, which sits in one or another countries. First 5 BRIC countries, and just for comparison, other countries. In Russia, by the end of the 2014, the overall FDI volume was just a half of what China had. Maybe it's not a bad thing, because China's population is 10 times bigger as Russia and Brazil as well. If you want, I can share the slides with you. And so the previous slides didn't show specific FDI into oil and gas sector. Yes. Dennis, I guess you have to go. John, if I have a flight to catch, sorry, I need to go. Your attitude towards the application of internal rights for the use of subsoil. Just briefly, my attitude is that right of subsoil use is a limited rights, but this is the right of the administrative law. So, this slide, I would like to admit that previous slides didn't show investment into the gas and oil sector, or oil and gas production sector. This sector is an important part of all investment in Russia, and these fluctuations show the fluctuation of FDI attraction, which happens at the same time with a regular growth of investment into oil and gas sector. This is in yellow. Starting from year 2000 till 2013, and we see a regular growth should we take the whole world at large. In this context, this section calls problems in Russia and in other countries, and here I feel a bit pro-Russian from a philosophical point of view. We, not we as foreigners, but Russians, my colleagues and Russian lawyers who practice in legal companies, who advise their clients in this sector, they accustomed to repeat the problem that we have. We have this problem, such problem, unpredictability, and so on and so forth. But my clients from majors, oil majors, they always remind me and they cut me if I start listing the problems in this sector. They say, try Nigeria, and they start listing the problem in Nigeria. I deal often with the projects in Kazakhstan, and I can compare. Some say that situation is worse in Russia in terms of attitude or policy towards investor. We have options of squeeze option in Russia and in Kazakhstan, but I wouldn't like that the situation here is worse than in Kazakhstan. So maybe investor. Sometimes I hear this from investors, from foreign investors, that it would be better to work in Russia because Russians look like Europeans and everything should be like in Europe. But of course, each country has its own specifics. And they also like to complain that it's pity that there is not much oil on Piccadilly, but unfortunately there is a taxation burden there, and there is no oil on Fifth Avenue. They have oil now, maybe not on the Fifth Avenue, but throughout the United States. In this context, I would say that the tolerance, the patience of the IOCs is quite high. For example, the history of nightmares, what we had here, and in terms of response or reaction of the foreign majors. We had Sakhalin 2 controlled by Shell, and after that, after the entry, so to say, of Gazprom, there was a certain pressure on Shell, and there were accusations that Shell is the worst violator of environmental legislation, that is the worst company. But on the very day of signing of the contract, when Gazprom started controlling this project, managing this project, there was a press conference, and the Russian president said, answering the ecological problems, he said that they were already solved. The same Kavikta project, when it was in the hands of foreign companies like BP, and they faced a very dangerous problem. They were even threatened to be ripped off the license. they need to gasify the Irkutsk region, but they're without pipeline network and system. It wasn't possible to comply with this requirement, but this license was handed over to Gazprom, and central authorities found some possibilities to revoke this requirement, so building the gas pipeline system in Irkutsk. So the legal regulation in oil and gas. Before, foreigners prefer to use PSA agreements, then it stopped without the grandfathers agreements, only 3 left of them. Then we start using the licensing system, tax, royalty, and on big projects, all shelf projects are implemented on the basis risk service agreement, where a Russian company holds the license. And 5 years ago, when I represented Chevron company, the first company to enter the negotiations with Rosneft, and where we met with Evgeny, the negotiation table, all foreign companies accused the Chevron company, or blame Chevron companies for entering these negotiations, and was prepared to deal with such institute, which was regarded as worse one compared with the classical one. Now all majors work in the same manner and accept this as reality. In recent example, Slumberger oil service company, but in the process of purchase of the EDC company, a drilling company. It's FAS said that this deal may go through, but it's doubtful or arguable. On a strategic list, so far negotiations continue. Some foreigners complain that, but fact is fact, and practically many governments play by the same strategic games or rules, including the United States and Great Britain. We see that Friedman and the things he wants to buy. So the super majors cannot afford not to be here. But unfortunately, Evgeny, who just left, said about this as well. There are many companies which should not be here. We're talking about the oil and gas companies, European and from other countries. United States, he says that even the biggest mining company is not present here for various reasons or complexities. There are some problems or certain degree of unpredictability or a certain perceived sentiment that there is a certain arbitrariness on the part of the state or in the relations between the state and the investor. I've been to many countries with huge natural resources, and here we have a second underlying layer of the problem. Maybe this is the first underlying layer. That is, the Russia is a big country, great power, and you can feel it. One thing for foreign companies to deal with the government, let's say in Angola or even in Brazil. The other thing in Russia, the fact remains the fact.
There are, of course, things of geopolitical nature which may be adverse, but you should remember that foreigners, subject to debates, of course, could always criticize the political climate and tension. But there's difference between the political climate and the business climate. Not everything in Russia is bad. We've heard today that in this context there are quite a few countries with attractive deposits and oil and gas fields. And it's not for me to list them. My last slides is to show the following. As we've heard, Russia needs both capital and technologies. And in the context of the political tension as of late and the sanctions, we all look towards Asia. Asia may be rich. They have capitals in China, but they don't have technologies that you need. And for offshore shelf deposits, it is a nice coincidence. It's providential that oil prices went down. It gave us all a pause to breathe. Of course, sanctions is bad news, but these projects, from the point of view of oil prices, are no longer feasible, no longer profitable, and this may be a nice pause for all of us to breathe in. As for the shelf openings in the Baltics and the Caspian, this may be good news for a broader range of subsoil users, and I agree with Denise that what has been done under Article 6 is a step forward. This is true. And the fact that now the Baltic is opening for those subsoil users who have already had exploration and survey licenses is good news again. It has been done pretty well from the point of view of legislative drafting. And again, it's maybe a nice coincidence that the Caspian Sea opened up for non-state subsoil users. This, of course, is due to the special status of the Caspian Sea. You've heard about the joint ventures that do not have any state involvement, and they've just obtained the production licenses there. It is very exciting news. We'll be looking forward to learning about the next steps. We also welcome the Gazprom Neft to KMG initiative, supported by others. This is what you could talk about, the Russification of risk-free operational agreement. It's good. It will be good for Russian legislation to have this arrangement in place, but you shouldn't be too hasty. You shouldn't expect it would be comfortably introduced. Not all of such arrangements should be governed by the Russian law, and the same is true of the selection of the venue for the arbitration. And again, this process is step by step, is stepwise, is going gradual. You need to ensure confidence and trust in the system, in the judiciary system, and the process is gradual, and you shouldn't be too hasty and should be trying to intensify your efforts there unnecessarily. Thank you very much, John. We have already abused our deadlines. We have no more than 2 to 3 minutes for the discussion and the questions from the audience. As a panelist, I thought I need to thank John for the support. This is not collusion, but what I found interesting, John, you probably heard about the legal system in Venezuela. And if you want to work there, Rosneft does, and there are US companies, other foreign companies. So would you contract local companies under the Venezuelan law in the state Venezuelan in the Venezuelan courts? And companies do that. Should Russia follow the example? Should it be more insistent? Do you think we need to insist on Russian courts and Russian law? I see the difference. As far as the key instrument, the concession or the production sharing agreement or standard licensing agreements, this is one thing. It is natural and logical and should be done under some external law, but risk service agreements involving foreigners for such contracts, apart from the key instrument which Rosneft or Gazprom would have vis-à-vis the governments, and it should be under Russian law. And the same is true of the selection of the venue for dispute resolution. We know Russia has issues, and even if you forget some possible potential political issues, the tensions between Russia and the West, if you forget about that, is an arbitrator of the arbitration court. I know there are very sensitive issues here in Russia as to the finality of the arbitration awards passed by any arbitrary court. This is a true issue. I'm sure it will go with time, but what I'm saying is you shouldn't be hasty in trying to insist on Russian laws in all, without exception, type of contracts. Any more questions? Thank you very much to all panelists. We have yet one more issue. We have very good news for you. It's my pleasure to congratulate on behalf of the Ministry for Natural Resources for his personal contribution to subsoil use and teaching in the sector, and because of the 20th anniversary of the journal that he represents, Mr. Nesterenko is getting this award. Well, this is a very nice finish to this roundtable panel. I'm sure we had a very good choice of speakers. Gender in this sector has a very broad range of complicated issues. Many thanks to everyone. All the best to you, and goodbye.